Welcome to Let's Talk U.S. Immigration. This is a special edition. On June 30th, 2026, the Supreme Court of the United States decided a case about birthright citizenship, the principle that a child born on American soil is an American, and the decision matters to millions of families, perhaps including yours. Imagine waiting years for a green card, while the one settled, certain thing in your life is that your child, born here, is a citizen from their first breath, and then wondering whether even that could be taken away. Today we explain in plain language exactly what the court decided, what it means for your family right now, and one quieter detail inside the decision that most headlines will rush past, but that matters for the longer future. One note before we begin. This is a fast-moving area, and we are speaking just after the decision, so please treat everything here as the picture as of this recording and confirm the current rules before you act. And everything you're about to hear is designed to inform and educate. Immigration law is complex, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
You know, it's just wild to think that the entire future of, millions of families today, it rested not on some modern debate, but on a decision made over 120 years ago.
Yeah, exactly.
About a young man in San Francisco and on a single sentence drafted in the aftermath of the Civil War. I mean, it's really something.
It's that counterintuitive reality of American law, right? We're all glued to our phones today, just endlessly refreshing news feeds about a 2026 Supreme Court decision.
Oh, absolutely.
But the justices themselves, they were looking backward. They were reading 19th century history to decide the fate of modern families.
Right.
So welcome to this custom deep dive. We're navigating a highly focused, really meticulous exploration of the legal research provided by attorney Chris Ingram and our legal team regarding today's ruling on birthright citizenship.
And we know your alerts are flashing.
Yeah.
I mean, the political commentary is just absolutely everywhere today.
It's overwhelming. So our mission here is to bypass the spin. Just bypass the anxiety, and deliver the unvarnished legal mechanics of what just happened.
Exactly.
We're looking specifically at families living and working in the United States on temporary visas. So H-1B, F-1, L-1, or families who are here without status.
Because bypassing that noise is honestly the most important service we can provide today. When a major legal challenge like this is resolved, the sheer volume of political reaction can completely obscure the actual legal reality. And clarity is really the antidote to that anxiety.
Clarity is the goal. And we are going to build that clarity step by step.
Yeah.
Now, the headlines everywhere are shouting about a 6-3 decision, right?
Right, the big number.
The big number. And that vote represents the immediate relief. The executive order that threatened birthright citizenship was completely struck down.
Which is huge.
It is. But, and this is key buried inside our legal team's research, is a second, much quieter number. Inside that 6-3 victory is a 5-4 split.
Yeah, that's the part that most people are completely missing today.
We are going to leave that as a mystery for just a moment, but I promise you, understanding that second number is the absolute key to protecting your family's long-term future.
It really is. It tells you exactly which horizon to watch.
Exactly. But before we get to the architecture of the Supreme Court's ruling, we have to look at the human stakes. Because the law isn't just an abstraction.
No, not at all. It applies to families sitting at their kitchen tables tonight, just trying to decipher what this means for their kids.
Right.
And our legal team provided a scenario in their research that serves as a composite of the clients they advise daily. So we can refer to them as Mira and Anand.
Okay, let's talk about Mira and Anand.
Oh.
They've been waiting in the employment-based green card backlog for 11 years.
11 years. Wow.
And Anand is a software engineer on an H-1B visa. Mira is raising their daughter, who was born in a hospital in Texas. And from her first breath, that little girl was an American citizen.
Just think about the emotional weight carried by this family. I mean, their entire existence in the United States has been defined by contingency.
Constant contingency.
Will the H-1B be renewed? Will the prevailing wage change? Will they be forced to just uproot their whole lives?
Yeah, and amidst a decade of that profound uncertainty, their daughter's citizenship was the one absolute guarantee they had.
Exactly. It formed the bedrock of their financial and educational planning. They assumed, based on over a century of legal practice, that their daughter's status was completely insulated from their own temporary visa status.
Right, and then an executive order is drafted that threatens to redefine the rules entirely. It basically proposed ending automatic citizenship for children of parents who are here lawfully but temporarily, like Anand on his H-1B, or parents who are here unlawfully.
And suddenly, the one safe fact in their lives is thrown into total jeopardy.
Total jeopardy. The psychological toll of that is immense.
It's staggering. For families caught in the green card backlog, their own wait is already stressful enough. Introducing existential doubt about their child's status compounds that anxiety exponentially. Which brings us to the core finding of today's decision in the case of Trump v. Barbara. The Supreme Court definitively struck down that executive order. The principle of birthright citizenship for children born on U.S. soil to parents on temporary visas or without status was upheld by a vote of 6-3.
So the order is gone. That is the immediate relief. But to understand why it was struck down, we have to look at the legal foundation the court relied upon.
Right, the history.
Yeah. This brings us back to that single sentence drafted after the Civil War. And I really want to spend some time here because you cannot understand today's ruling without understanding the 14th Amendment.
The 14th Amendment is the centerpiece of this entire debate. It was ratified back in 1868, and the opening line of Section 1 is what matters here.
What does it say exactly?
It reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside."
Okay, I want to pause on those specific words, subject to the jurisdiction thereof. Because based on our attorney's research, that phrase is the entire battleground, right?
It really is.
I remember reading about the debates in Congress back in 1866 when they were drafting this thing. The original goal was to overturn the Dred Scott decision.
Right, the 1857 ruling that horrifically declared that Black Americans could not be citizens.
Exactly.
I am still in the process, but so far my experience has been very positive. The firm is genuine, makes no false promises, and is always prompt and honest in communication. Stefania Perez is very helpful in clarifying doubts and leaving no loose ends.
The drafters wanted to enshrine in the Constitution a geographical rule.
Yeah.
If you are born here, you are a citizen, period, regardless of your ancestry.
Yes, but, and this is a big but, they added that jurisdiction clause as a carve-out.
So what was that carve-out actually for?
Well, the historical record shows that carve-out was originally intended for very specific groups. Primarily, it was meant to exclude the children of foreign diplomats.
Okay, that makes sense, like an ambassador.
Right. A French ambassador living in Washington, D.C. is subject to the jurisdiction of France, not the United States. So their child born here does not automatically become an American. It also applied at the time to Native American tribes who were considered separate sovereign nations.
So for 150 years, the rule has been applied almost universally based on geography. If you are born in Texas, you are subject to American laws.
You have to obey the speed limits.
Right. You obey the speed limits, you pay local sales taxes, you follow local statutes. Therefore, you are subject to its jurisdiction and you are a citizen.
Exactly. But the executive order attempted to introduce a completely new, vastly narrower interpretation of that phrase.
How so?
The legal theory behind the order argued that jurisdiction means more than just territorial obedience. The argument was that it requires a complete political allegiance that a temporary visitor or an undocumented immigrant simply does not possess.
I want to make sure we treat that opposing argument thoroughly because, 3 Supreme Court justices actually agreed with it today. It wasn't just some political talking point. It was a formal legal theory.
That's right.
So how exactly did the dissenting justices rationalize the idea that an H-1B worker isn't fully subject to U.S. jurisdiction?
Well, the dissenting justices relied on a theory sometimes called consensual citizenship.
Consensual citizenship.
Okay. Right. They argued that citizenship requires mutual consent between the sovereign nation and the individual. If a person is only permitted to be in the United States temporarily, like under the strict conditions of an H-1B or an F-1 student visa, their ultimate allegiance legally remains with their home country.
Their presence is conditional.
Exactly. Their presence is conditional. So the dissent argued that because the parent's presence is conditional, they are not completely politically subject to U.S. jurisdiction in the way a permanent resident or a citizen is. Therefore, they argued, the constitutional mandate shouldn't automatically apply to the child.
So they are essentially arguing that jurisdiction isn't just about whether the local police can arrest you for breaking a law, but whether you have a permanent, recognized political bond with the nation itself.
That's the crux of their argument, yes.
But the majority of the court, the 6 justices who struck down the order, they rejected that. They looked at that argument and said, no, that is not what the Constitution means.
And to prove it, they leaned heavily on a specific case from 1898.
Right. United States v. Wong Kim Ark.
It is impossible to overstate its importance to today's ruling.
So who was Wong Kim Ark?
He was born in San Francisco in 1873. His parents were Chinese citizens who resided in California. And in 1890, Wong traveled to China for a visit.
Okay.
But when he tried to return to the United States, the collector of customs at the port of San Francisco denied him entry.
That's because of the Chinese Exclusion Act, right?
Exactly. The Chinese Exclusion Act of 1882 was a federal law that explicitly prohibited the immigration of Chinese laborers and, crucially, completely barred Chinese immigrants from ever naturalizing as U.S. citizens.
So they could never become citizens legally.
Right. So the customs official argued that because Wong's parents were subjects of the Emperor of China and were legally forbidden from becoming Americans, Wong himself could not be a U.S. citizen despite being born in San Francisco.
Wow.
Yeah. He was actually detained on steamships in the harbor while his case was fought.
That is incredible. And, the government's argument in 1898 sounds remarkably similar to the argument behind the 2026 executive order. The government was saying, your parents have no legal pathway to permanent political allegiance here, so you don't either.
The parallels are striking. I mean, the Solicitor General of the United States argued the case in front of the Supreme Court, making exactly that point. But in an opinion authored by Justice Horace Gray, the Supreme Court ruled in favor of Wong Kim Ark.
So they sided with Wrong. What was the reasoning?
They examined the English common law concept of jus soli, which means the right of the soil. They determined that the 14th Amendment codified this common law principle into our Constitution.
Okay, so let me unpack this. Justice Gray essentially said that the citizenship of the parents does not dictate the citizenship of the child born on U.S. soil.
Precisely.
Yeah.
He established that the only exceptions were those children born to foreign sovereigns, diplomats, or alien enemies in hostile occupation.
Right.
Because Wong Kim Ark's parents were living and working in San Francisco, they were subject to the local laws, the police power, and the tax guidance of the United States.
Just like anybody else living there.
Right. They were subject to the jurisdiction thereof in a territorial and legal sense. Therefore, their child was a citizen at birth.
And today, in 2026, the Supreme Court majority reaffirmed that holding.
Yes. They stated that a parent's temporary visa status, or lack of status entirely, does not alter the fact that they are subject to U.S. laws while on U.S. soil, the Wong Kim Ark precedent holds.
It's just fascinating how legal architecture works. Like I think about the analogy of an anchor. You have a family today worried about the turbulence of their H-1B, and the 14th Amendment acts like an anchor for these families. No matter how turbulent the green card wait gets, the anchor holds the child safely in place. And their salvation is a decision written by a judge 128 years ago about a young man detained on a steamship.
It really is profound when you look at it that way.
Well, we've established the deep history, but let's shift to the immediate reality for you, the listener. Because based on our team's legal research, we need to outline the practical, everyday implications of this 6-3 decision.
Absolutely.
I want to run through the specific categories so no one is left guessing tonight.
Good idea. Our attorneys have been very specific about the statuses covered by this reaffirmation. If you are in the United States on an H-1B specialty occupation visa, your child born here is an American citizen.
Okay, what if you're the spouse?
If you are a spouse on an H-4 dependent visa, your child born here is a citizen.
What if you are studying here? Like someone on an F-1 visa who might only be in the country for 4 or 5 years to get a degree.
The duration of the visa does not matter. The F-1 student visa is completely covered. If your child is born on U.S. soil, they are a citizen.
And other employment visas.
The same applies to intracompany transferees on L1 visas, NAFTA professionals on TN visas, and O1 individuals with extraordinary ability.
And what about families who are here without any legal status?
It firmly applies to those who are in the country without any current legal status as well. The constitutional guarantee relies on the location of the birth, not the paperwork of the parent.
Okay, let me push back on the timeline here because I think this is a source of hidden anxiety for a lot of people.
Yeah.
The executive order was announced months ago.
Right.
And there has been this terrifying gap period where it was debated on the news, challenged in court, and eventually appealed up to the Supreme Court. The listener might be thinking, my baby was born last month. Are they caught in some sort of retroactive limbo because they were born while the order was technically alive?
That is a great question, and the answer is no. There is no retroactive limbo because of the administrative reality of how federal courts operate.
Okay, how so?
The executive order never actually took effect.
Wait, really? So it was just a piece of paper that never had enforcement power?
Exactly. From the very moment the president signed it, civil rights organizations and immigration advocates filed lawsuits, and lower federal courts immediately issued nationwide injunctions.
Right, injunctions.
An injunction is a judicial order that pauses the implementation of a policy while its legality is being debated. The policy was frozen on day one.
Oh, wow.
So now that the Supreme Court has struck it down completely, it means the order never lived for a single second in practical enforcement. There is zero gap, period.
That is incredible.
Yeah, if your child was born during the months this was being litigated, their citizenship is just as absolute as a child born 20 years ago.
That is a massive relief. It means there is no special documentation required. You know, a listener doesn't have to go to a federal building to get some kind of Supreme Court validation stamp on their child's records.
No, nothing changes regarding how you prove citizenship. A standard birth certificate issued by a U.S. hospital or a vital records office remains the absolute, unquestionable proof.
Perfect.
You use that birth certificate to apply for a U.S. passport, to obtain a social security number, to enroll in public schools, and to secure all other rights. The bureaucratic process is completely uninterrupted.
Okay, so if the child's citizenship is unquestionable.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram, and we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself.
Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it! We did it!
Oh my God, I got my visa! Yes, I did it!
I have to ask a vital, clarifying question on behalf of the listener about the parents. This is a common misconception and, frankly, a major political talking point.
This raises an important question, yes. Let's hear it.
If Mira and Anand's daughter is definitively an American citizen today, does that provide an immediate benefit to Mira and Anand? Like, does it speed up their own green card journey or protect Anand from losing his H-1B status if he gets laid off?
It is crucial to separate the status of the child from the status of the parent. This Supreme Court ruling protects the child exclusively. It is a ruling on birthright citizenship, not on adult naturalization or visa allocation.
So having a citizen child does not grant the parent a free pass?
It does not. The parent's independent legal track remains entirely unchanged. Let's look at the mechanics of immigration law. A U.S. citizen child can eventually sponsor their parents for a green card, but under the Immigration and Nationality Act, they cannot do so until they turn 21 years of age.
Wow. That's a 2-decade wait.
Yes, it is not a shortcut. For families navigating the H-1B system or the employment-based green card backlog, the timeline has not shortened. The risks associated with job loss or visa non-renewal remain exactly the same.
Okay, so the journey continues as before.
Yes. The profound relief of today's ruling is that the fear regarding the child has been eliminated. You can continue to build your family's plans knowing your child's foundation is secure, but you must still actively manage your own visa strategy just as you did yesterday.
The relief is deep, but it is narrow. The child is safe. The parents must keep navigating the system.
That's the reality.
Well, we've spent a lot of time on the 6-3 decision, the history, and the immediate relief. But here's where it gets really interesting. We need to transition to the future. At the very beginning of this deep dive, we promised to explain a quieter number hidden inside the legal research.
Ah, yes, the 5-4 split.
Right. We talked about a 5-4 split buried within the 6-3 victory. It is time to unlock that, because this is where the legal architecture gets truly fascinating, and it dictates exactly what families need to watch going forward. Can you unpack the votes for us?
I'd be happy to. The Supreme Court rarely acts as a monolith, even when a majority agrees on an outcome. 6 justices voted to strike down the executive order. However, they did not all agree on the legal reasoning required to do so.
Interesting.
They reached the exact same destination, but they took 2 completely different paths.
I want to break down those 2 paths, because our legal team meticulously outlined this. 5 of those justices looked at the executive order and declared it fundamentally unconstitutional, right?
Yes. They grounded their decision entirely in the 14th Amendment and the Wong-Kim Ark precedent we discussed earlier. They stated that the Constitution grants birthright citizenship, the president cannot rewrite the Constitution with an executive order, and therefore the order is void. That is a constitutional ruling.
But a constitutional ruling by 5 justices is just a simple majority. The final vote to strike down the order was 6-3. So there was a 6th justice who agreed the order had to be struck down. If they didn't use the Constitution, what legal tool did they use?
That crucial 6th justice filed what is known as a concurring opinion. They concurred with the judgment, meaning they agreed on striking down the order, but dissented from the constitutional reasoning. Instead, this justice based their decision on statutory grounds.
Statutory grounds, meaning a law passed by Congress rather than the Constitution itself.
Specifically, they pointed to the Immigration and Nationality Act of 1952.
The 1952 Act.
Yes. This is the massive foundational piece of federal law that governs modern U.S. immigration. In Section 301 of that act, Congress formally codified birthright citizenship into federal statute.
Let me synthesize this with a structural analogy. Tell me if this holds up. Let's imagine birthright citizenship as a house.
Okay, a house.
The 5 justices who made the constitutional ruling are saying this house is built on deep, unmovable bedrock. It is welded to the earth. The president cannot move bedrock. In fact, no one can move bedrock without passing a constitutional amendment, which requires a 2/3 majority in the House, a 2/3 majority in the Senate, and ratification by 3/4 of all the states, which is essentially impossible in modern politics. The bedrock is fireproof.
The analogy is very sound. A constitutional ruling places the issue far beyond the reach of everyday legislative tinkering or executive action.
But the 6th justice is looking at the same house and saying, no, it isn't built on bedrock. It is built on a massive concrete foundation. That concrete foundation is the 1952 law passed by Congress. Now, the concrete is incredibly strong today. It easily shattered the president's executive order because the president doesn't have the authority to unilaterally destroy a foundation poured by Congress. The 6th justice is basically saying the president overstepped the separation of powers.
That is exactly the core of the statutory argument. The president attempted to act where only Congress has the authority to legislate.
But here is the terrifying caveat to the concrete foundation. Because Congress poured that concrete in 1952, Congress theoretically owns a jackhammer.
Yes.
A statutory ruling implies that while the president can't change the rule alone, Congress could theoretically pass a new law, a new piece of legislation that chips away at the concrete and draws new exceptions to birthright citizenship.
You have identified the exact vulnerability that our legal team highlights in their research. By explicitly relying on the 1952 statute rather than the 14th Amendment, the 6th justice left the door open for the legislative branch. And if you combine that one justice who believes Congress has the power to change this with the 3 justices who dissented entirely and believe the executive order was perfectly legal, you suddenly have 4 justices who believe the bedrock is not untouchable.
Well, let me do the math on that. 5 justices say the bedrock is absolute. 4 justices believe either the legislative or executive branch has the power to alter the rules. So the true underlying split on whether Congress can ever touch this is 5-4.
That is the quieter number. It is the most significant long-term revelation of today's ruling. If you only read the headlines, you might assume the Supreme Court permanently slammed the door on any future debate regarding this issue.
Right.
But analyzing the varied opinions reveals that the door is heavily fortified, but perhaps not welded shut against congressional action.
I feel like we just handed a listener a heavy dose of anxiety after promising them relief. How does a family reconcile the immediate victory with this looming 5-4 vulnerability? We need to contextualize this so it doesn't just induce panic today.
We reconcile it by understanding the profound difference in speed and difficulty between an executive order and a congressional statute.
Okay, let's contrast them.
An executive order is drafted in secret and signed with a pen. It attempts to change reality overnight. That is terrifying. But the court today neutralized that specific threat. The executive branch, acting alone, has been definitively checked.
Which means the only avenue left is Congress.
Passing a highly controversial bill through the United States Congress is a monumentally slow, highly visible, and complex process. It requires drafting a bill, surviving committee hearings, securing a majority in the House of Representatives, overcoming a 60-vote filibuster threshold in the Senate, and obtaining the president's signature.
It's the ultimate Schoolhouse Rock reality check. It happens entirely in the public eye, over months or even years.
Exactly. Knowing about the 5-4 split does not mean your child's citizenship is in danger tomorrow. It provides you with informed awareness. It tells you exactly which horizon to watch Congress rather than the wrong one.
Armed with that knowledge, we need to talk about how to process the news environment. Today is June 30, 2026. The legal research notes that within hours of the Supreme Court publishing its opinion, the political reaction was explosive.
Oh, it certainly was.
Just rapid-fire events. The White House issued a statement condemning the ruling. The Speaker of the House announced intentions to draft a new bill. Several senators held press conferences vowing to introduce legislation or even a constitutional amendment to redefine birthright citizenship.
Right.
I'm glad I found Chris Ingram. They helped me tremendously with my EB1 journey. My primary caseworker, Laura, is highly experienced in handling EB1A cases. She reviewed my documents thoroughly and crafted strong, well-supported arguments. Thank you for all your efforts in making this a success.
If a listener is watching the evening news, they are seeing politicians promise to do exactly what we just said Congress might theoretically try to do.
What's fascinating here is that we must rigorously separate political rhetoric from legal reality. The statements made today are expressions of political intent. They are designed to appeal to constituencies and signal ideological positions.
They are not legal developments.
Exactly. There is an insurmountable difference between a press conference and a passed law. Politicians frequently announce their desire to pass sweeping legislation on complex topics: healthcare, tax reform, immigration. Very few of those press conferences ever materialize into signed statutes.
Right, because of all those hurdles we just talked about.
The hurdles, the committees, the House votes, the Senate filibuster are specifically designed to prevent rapid, sweeping changes to the law. So strictly speaking, no bill has passed. When you see a senator on television declaring they will end birthright citizenship, you must recognize that as the beginning of a years-long political battle, not an immediate change to your legal standing.
The blueprints might be drawn up, but the House hasn't been built. No bill has passed. Your child's citizenship is secure today.
Absolutely.
But there is one other specific news item from today that our legal team flagged, and it has the potential to cause serious confusion for families on work visas.
The DOJ announcement.
Yeah, the Department of Justice also held a press conference today. They announced a major crackdown and prioritization of investigations into birth tourism fraud schemes. And honestly, when someone on an H-1B visa hears the DOJ say the words birth tourism and fraud in the same sentence as citizenship, it is incredibly alarming.
It is alarming, but it requires precise definitions. The DOJ's directive regarding birth tourism fraud is a highly targeted law enforcement initiative. It operates on an entirely different legal track than the situation of an employment-based visa holder.
Okay, walk us through the mechanics of that difference. What exactly is the DOJ targeting?
Birth tourism fraud typically involves organized criminal enterprises. These networks coach individuals living abroad to apply for B1, B2 visitor visas under false pretenses.
So they are lying on the application.
Yes. The applicants lie to consular officers, claiming they are traveling for sightseeing or business. when their sole intention is to enter the U.S. to give birth and secure a passport for the child, often returning to their home country shortly after. The DOJ is targeting the fraud and misrepresentation involved in obtaining the visa.
They're targeting the lie told at the embassy.
Correct. Now, contrast that with an individual on an H-1B specialty occupation visa or an F-1 student visa. You did not lie to obtain your visa.
Right.
You applied transparently, demonstrating your employment offer or your university acceptance. You went through background checks. You were living in the United States, paying taxes, renting an apartment, and working or studying legally. If you have a child while building your life here, you are engaging in the natural course of human existence, not a birth tourism fraud scheme.
So if Anand is working as a software engineer in Texas, his employer sponsored his H-1B, and Mira gives birth at the local hospital, the DOJ announcement has zero relevance to their lives.
None whatsoever. The Supreme Court's decision absolutely protects their child. It is vital not to conflate a targeted criminal investigation into visa fraud with the broad constitutional right that was just affirmed for people living within the jurisdiction of the United States. They are separate conversations entirely.
I think this is the appropriate moment for a strict neutrality check between us.
Yeah.
The research we are discussing involves deeply polarizing political figures, contentious executive orders, and varying judicial philosophies. We promise to bypass the noise.
And maintaining objectivity is the only way this analysis remains useful. The law functions through mechanics, not emotions. Our responsibility is exclusively to explain how those mechanics operate.
We are not here to offer an editorial opinion on the administration that drafted the executive order. We're not criticizing the 3 dissenting justices who would have allowed the order to stand. We simply explained their legal rationale regarding consensual citizenship. And we are not taking sides with the politicians holding press conferences today, whether they are celebrating the ruling or vowing to overturn it. We report the mechanics of the government's response as factual data points for you to be aware of. If the Speaker of the House announces a new bill, we inform you so you understand the legislative timeline, not to instruct you on whether that bill is morally right or wrong.
The families relying on this information require factual, unbiased legal clarity to make critical decisions. Injecting political ideology into this deep dive would compromise the very clarity we are tasked with providing. The Supreme Court has ruled, the varying legal rationales have been published, and the political branches are reacting. Those are the facts. The legal reality you are standing on is what matters.
And as of today, that ground is holding firm. Let's bring this comprehensive exploration to a close. Let's return to Mira and Anand, sitting at their kitchen table tonight. After months of anxiety, after reading the dense legal history of 1868 and 1898, and after deciphering the 5-4 split, what are the 3 definitive takeaways we can offer them and you, the listener?
The legal research synthesizes into 3 distinct pillars: the relief, the perspective, and the quiet awareness.
Walk us through the first pillar, the relief.
First is the relief. Mira and Anand's daughter is an American citizen. That is a concrete legal fact reaffirmed by the highest court in the land today. The attempt to redefine the 14th Amendment through executive action failed. Her standard U.S. hospital birth certificate remains the absolute proof of her citizenship. The foundation of her life in this country is secure.
That is wonderful. The second pillar, the perspective.
The perspective. The executive order that caused such profound anxiety was not only struck down, but because of federal court injunctions, it never took effect for a single day. There is no retroactive gap to fear. The system worked to freeze the policy while it was reviewed, meaning your child's status was never legally interrupted. The bureaucratic reality remains unchanged.
And the final pillar, addressing the nuance we uncovered, the quiet awareness.
The quiet awareness. Because of the quieter 5-4 split regarding whether Congress possesses the authority to legislate on this issue, there will be a longer conversation in the years ahead. You will see political attempts to pass new laws. But you can hold this awareness with informed calm, not dread.
Because you know the timeline.
Exactly. You now understand that the legislative process is slow, visible, and incredibly difficult to complete. You know how the system works, which means political press conferences will no longer catch you off guard. You watch Congress with informed calm, but you continue building your life today.
The relief, the perspective, the quiet awareness. That framework strips away the panic and replaces it with knowledge. We covered an enormous amount of ground in this deep dive, from the debates of the post-Civil War Congress to the intricate statutory logic of the 1952 Immigration Act. And we are curious which part of this complex machinery surprised you most. Was it the decision itself, the narrow exceptions that have always existed, or the quieter split inside the vote regarding Congress? Tell us in the comments, because the part that surprised you is very likely something another family is wondering about too. Your questions elevate the conversation for everyone.
Sharing that understanding is vital. And while we celebrate the legal security of the children today, it is essential to remember that a family stability is an interconnected structure. The security your children were just guaranteed is one you build for the whole family, one careful step at a time. The child's citizenship is secured, but the foundation beneath the entire family still relies on the parent's ongoing visa journey.
That is the hard truth of the immigration system. The child is safe, but Mira and Rand are still in year 11 of their green card wait. If you are breathing a sigh of relief tonight about your child, but you are still carrying the heavy burden of the H-1B process, we have the resources to help you navigate that as well. I strongly encourage you to listen to our legal team's specific episodes on the intricacies of the H-1B visa and, crucially, our deep dive on what happens when a sponsored job is lost. Those episodes are meticulously designed to help you protect the rest of your family's foundation.
We will see you over there.
So let us leave you with the heart of this special edition. Birthright citizenship, the principle that a child born on American soil is an American, has been part of who this country is for more than 150 years. And on June 30th, 2026, the Supreme Court kept it that way, striking down the executive order that would have changed it by a vote of 6-3. For the families we serve, parents on work visas, parents in the green card line, parents without status, the message is reassurance. A child born here is a citizen, and that is secure, and a United States birth certificate remains proof of it. There's a longer conversation still ahead about whether the law could one day be changed by Congress, and we will explain each chapter as it comes, but today the ground holds. The strategies in this discussion are for educational purposes only and reflect the picture as of this recording. Your situation is unique, and the law offices of Chris M. Ingram are here to help your family. If you have questions about your family's immigration journey, visit breakthroughusa.com for a free consultation. Thank you for listening, and we will see you next time.